Yeah, let's move on to chapter 13. I'll try to get through this one a little bit quicker. We're talking about crime and not trying to diminish crime, but crime in the study of business law. It's been a fairly recent phenomenon. We didn't really talk about it a lot, but what's happened is it's become much more in our public view. We're seeing more things, and more things, frankly, are starting to be discussed. I put this in there. It was kind of this had to do with the I think we were talking about it in a face-to-face class, but this has to do with that Westboro Baptist Church that was protesting funerals or protesting, I don't know if that's the right term for it, but funerals of American service people, and basically shouting and saying that America deserved it because we were accepting of gay marriage and whatnot, and the Supreme Court actually upheld their right to do that, and it kind of talks about this, that really no matter how outrageous their actions were, they were protected by the First Amendment, and it's one of the bad things, I guess, that we have to accept sometimes, in a free society. So it was an interesting case, one that you might want to go take a look at, but the Westboro Baptist. So criminal law, right, provides a means to punish wrongdoers who affect ownership of property. It's wrong against society. We talked about that, crime versus civil. Okay. And in many cases, remember that in many cases there are both civil and criminal aspects or things related to one particular action, right? If you're speeding and you wreck somebody else's car, you've both committed a crime in speeding, misdemeanor, but you've also committed a civil wrong or a tort, right, against the person, and so you can be found guilty or responsible for both, right? Okay. So originally, again, we didn't talk a lot about it in business law, probably before me, but 20, 30 years ago, and we certainly have now, and what's done it, and you guys, Bernie Madoff's getting a little bit old, but Bernie Madoff was something we talked about a lot just 5, 6, 7 years ago, and again, probably out of your guys' sight and mind, but he carried on this tremendous Ponzi scheme. It was unbelievable, the sophistication of it, and the fact that supposedly he was able to do it himself, and they haven't, other folks in his office, they haven't really nailed. Huge. The folks at the time, now this will take some explaining maybe, but I think had lost, reportedly billions of dollars, but the thing about that was that was the statements that they were receiving, that they thought they had that much money, and he had been reporting huge gains for them, for years, even though they had never really gained that much, and their original investment was substantially smaller, right? If the guy thinks he's returning huge, investment gains to you, and it's going to make your, if you had 100,000 and it was earning, 24% a year for 10 years, that 100,000 had become, close to $1 million, right? So you might be getting a document from Mr. Madoff that says you have $1 million, after 10 years, when you actually only invested 100,000, and the other 900,000 was always fake, and so. Some discrepancy over what was reported as a loss and what was actually lost. But Martha Stewart, yeah, she's kind of back. She's made it back, but she was found guilty of obstruction of justice, not actually. She was never found guilty of insider trading. That's what she was accused of. The reason she was found guilty of obstruction of justice, not insider trading, is that she wouldn't provide the information to the authorities that probably would have found her guilty of insider trading. Okay? And you guys don't remember the whole Enron thing. Enron was a huge scandal that took place probably 10, 12 years ago. Interesting. It was, again, a really interesting case. Cost tens of thousands of people retirement dollars, people that had worked for Enron, that had their retirement accounts there and whatnot. So anyhow, crimes wrong against society is prohibited by statute. It's inherently wrong, right? That's probably what malum in se means. I'm not even sure I'm pronouncing that correctly. So, okay, deemed wrong by a legislature. So this must be just inherently wrong, one of those things like stealing that we deem to be inherently wrong, and then legislature, right, has deemed some other things to be wrong, right? We've got things like white-collar crime, business entities, and this gets, how do you criminally charge a business entity? You can, certainly, and you can fine them. Those things happen all the time, but you can't throw, you can't throw Enron in jail. Some of the principles of Enron you can, but that's a whole different story and becomes a little bit more difficult to prove sometimes. It can go to desk workers, accountants, attorneys, officers, all types of things. There was a crime, one time I remember talking about a business law class several years ago where the guys were, they worked in a warehouse, and it was for some magazine, I don't remember, Newsweek, Fortune, whatever, back when print media was far more important, but there was an article that was coming out by this magazine that was, I think, let's call it damning maybe to a certain company, and they knew then that when this hit the street, when the article hit the street, it would cause the stock of that company to go down, and so they stole a couple of those, and they gave them to, didn't give them, but they went to work with a stockbroker, and they used that information to profit from that. They too were accused of a white-collar crime. So even the dock worker, even the forklift operator, whatever, can be accused of those types of things, right? Forgery, embezzlement, it's down here. Decent amount of forgery and counterfeiting, and then some fraud, per year, a couple 100,000 if you combine all those. Felony is there's an indictment by grand jury, fine or imprisonment. I think white-collar indictments might be by grand juries. I think smaller ones. We've had felonies here, certainly felonies on more of a local level. The indictment comes from just the county, in our case, the county attorney. Misdemeanors, government charge, right? There can be fine, jail less than a year, those types of things. Intent's a huge deal. Did somebody intentionally commit that? Was it willful, knowingly, voluntarily? As you might imagine, if you're the guy or the gal working in the back room and the boss is just giving you some numbers to crunch and do those types of things, you might know that the number crunching that you're doing is for an illicit purpose, right? And so your involvement is neither willing or knowing or voluntary, right? And so you wouldn't be prosecuted in that case. So those crime, there has to be some intent, and intent, again, one of those gray areas. It's probably difficult to prove. Pleas can be guilty or not guilty, or a no contest. There's the good old Latin, I think, term for it is nolo contendere or something like that. But no contest. Montana, I've read stuff, and they refer to it as an Alford plea, which I believe is similar to, if not exactly the same as, no contest plea. It's what that means is, and it's probably on the test, it's an admission that there's enough evidence against you to result in a conviction, but not an admission of actually doing the crime. People might do that. They might enter a no contest plea because later evidence might find that they aren't guilty, right? And so they want to leave that open. Basically, when they say they're guilty, they're saying they're guilty. It's almost like a confession, right? But if you say no contest, it's not a confession. It's an admission that there's enough evidence, but not that you necessarily admit to doing the crime. Criminal conviction may be basis for civil damages suits. So again, remember, Those two are not necessarily separate, and the double jeopardy clause doesn't protect you one from the other. Just because you're acquitted or found innocent of a criminal doesn't mean that you can't be found responsible under a civil suit. My computer decided to strange. A grand jury, they're called in the case of felonies, larger felonies. Again, I think small felonies, state kind of felonies that happen in our area, the indictments come down from the county attorney. That's the person then that's kind of solely responsible, I guess, for determining whether enough evidence exists to proceed with the trial. But in a grand jury case, when we talk about those federal crimes and whatnot, they determine by, the grand jury does, if there's enough evidence to proceed. And grand juries, I think, it says citizen jurist 23. I don't think there's 23 jurists on a grand jury. I don't know what the 23 there means, but they don't determine the guilt or innocence. Again, they're just determining whether or not there's enough to go forward. They may start with 23. There might be, and they may have panels, because I know that folks that I know that have served in grand juries, they've been impaneled for a year basically, and there might be 23, and they pick 12 per case or something possibly. There's always that presumption of innocence. Grand juries have the right to subpoena. They can issue subpoenas. And their proceedings, unlike other proceedings in our justice system, are secret. Okay, so they can go behind closed doors and talk about things and do things. But again, they're not determining the guilt or innocence. They're only determining if this thing should go forward. Constitutional protections, right? We've been through the Bill of Rights. Provides some protections, right? It also protects businesses from excessive regulation. It's almost becoming a joke here recently, but it's supposed to protect businesses from excess regulation. So, and individuals too, but I'm not sure that that's so true anymore. The Fourth Amendment gives us protection from unreasonable searches and seizures, right? And I put this in as an example, and that extends to certain civil matters. There's two cases that I found kind of a little bit funny, I guess, and sort of kind of related in terms of some of the activities, or that they both revolved around bathrooms. There was an underage party that was taking place. This happened in Montana, and I forget, and it's been 4, 5, 6 years ago, but there was drinking and that type of stuff going on, and the cops raided the party, and they got into the house, and they started issuing tickets, MIPs, to the folks in the house. Well, they knocked on the bathroom door, and there was a young lady in there, and she said, "Go away, I'm going to the bathroom." And they said, "No, we need to issue you this ticket." And I'm sure they waited a reasonable amount of time, and she just kept saying, "Go away, I'm not going to open the door." Well, they either broke in, or bathroom doors, usually you can jiggle the lock and get in, and so they did whatever, and they went in and they issued her a ticket, and she fought the ticket, or her and her parents fought the ticket, and they were successful. And the court said that she was in a bathroom, even though it was not her bathroom, she was one of the guests. She was entitled to an expectation of privacy that was not allowed. And so she actually got out of that ticket. Now, on the other hand, the other case involved it was a convenience store. This was not in Montana, but a couple had entered into one bathroom in this convenience store, and apparently there was some noise making of a certain type coming from the bathroom. In other words, they were engaged in some amorous affairs or amorous activities, and the cops were called. So the cops go in, and it's again a public restroom in this case, and they go in, and not only do they find him engaged in that kind of an activity, but they find that they have some drugs. Well, they sued and said they had an expectation of privacy, but in this case, because the bathroom was a public restroom, they didn't have an expectation of privacy. Generally, we would assume that there's an expectation of privacy. Some businesses don't, and what do we mean by that? Well, businesses are subject to certain regulations. Banks, for example, and it's just from my own experience, and they're examined, right? They're granted some protections under the FDIC, or some insurances under the FDIC, which is a quasi-government agency, and so they're subject to audits. and so there's no expectation of privacy there. So if the bank auditor walks in from the FDIC or from the Federal Reserve for that matter, you know, you got to let them go through the books, right? There is no expectation of privacy there, and that exists for other businesses as well in other areas. Okay, where privacy is not in the Constitution, isn't that amazing? Our rights to privacy arose from common law decisions, right? Fifth Amendment allows us to not testify, right, against ourselves. Okay, we can be required to produce evidence, and we can be compelled to testify against maybe somebody else, or at least be compelled to testify, right? Okay, business records can be obtained. It does protect a sole proprietorship entity, because that's a personal freedoms then that a person might have, right, in terms of maybe producing documents, etc., etc. So when you hear somebody say, I plead the Fifth, again, it means that they have a right not to testify against themselves or testify in any matter that might incriminate them. Okay, and so that's what that means. But again, it doesn't mean that they have a right. This is the Martha Stewart case, right? So she was accused of insider trading. Long story. I won't get into the whole story. And basically, the law enforcement came to her and said, we want these documents, emails in particular. And she said, no, I'm not going to provide those. And they said, no, you have to. And they got a subpoena and whatnot. The court issued a subpoena, and she still refused. And so at that point, it became obstruction of justice, which they found her guilty of. But because she didn't produce the documents, never did, she was never found guilty, actually, of insider trading. Okay. Double jeopardy is also in the Fifth Amendment, and that says we can't be tried to conclusion for the same criminal offense. Okay, we cannot be tried to conclusion for the same criminal offense. So if you get tried for a robbery, felony, boom, and you're found innocent, they can't bring you back and try you again. Okay, could you be sued civilly? Yes. Okay, yes, you could. Old O.J. Simpson case where he was accused of murdering his ex-wife and her boyfriend. He was found innocent of that crime, but he was sued by the families and found that he, in fact, was responsible for a wrongful death and owed them, I don't know, $35 million or something like that. Still does. Okay. So double jeopardy doesn't apply to the difference between civil and criminal, but it does apply to being tried to conclusion for the same criminal offense twice. The Sixth Amendment provides protections for speedy public trial, right? Again, I've asked our county attorney, how come so many of these cases you see them in the paper, and one that's been recent was Shad Houston. It wasn't the county attorney that would have been involved in that, because that was Fed stuff, but it's gone on for a couple years, right? And the reason for that is not the public part of it. The prosecution has been ready to go and has wanted to go ahead with the trial, but in almost all those cases where it takes a long time, it's because the defense has asked for more time, right? We're entitled to a trial by jury, and I think what's it say? I think if it's above $20. And that was the original amount put in the Constitution. It seems interesting that we would hold to that so many years later, when $20 back then is probably worth $1,000 today at least. So we're entitled to be informed under the Sixth Amendment, be formed of the charge, and confront our accuser. There's the courts have ruled that there's some exceptions to that when we get into sex cases, child especially. Child abuse, child sexual related cases, those types of things. We can subpoena witnesses, and we're entitled to the assistance of an attorney, right? Getting back to the Miranda rights. So what are some of the specific business crimes? Fraud, conspiracies, obstruction of justice, making a false statement or fraudulent types of a statement, larceny, that's embezzlement, stealing, basically. RICO, I can't remember what RICO stands for. We'll get to that. I'm sure racketeer, influenced, corrupt, something. Anyhow, cyber crimes, endangering workers, or crimes that are happening, right? So generally, when corporations are charged with crime, corporate officers can also be criminally charged. And the answer is certainly they can be criminally charged, I don't know about the generally. Personally, I guess I'd have to go back and look at the text and see what the text says in that case, because oftentimes corporations are charged without the corporate officers being charged a lot. So, excuse me, I gotta take a call. Okay, sorry for that interruption again. I kind of expecting a phone call or two. So yeah, it's a good it's a good question. Can they be criminally charged? The answer is absolutely. Are they? Maybe not as often as what we'd like. Employees of some businesses do not have Fourth Amendment, and yeah, we already talked about that, and that would be absolutely true, right? So fraud, right? Must be a scheme to defraud, right? Got to be an intent to mislead, misstatement of fraud, misstatement of facts is probably what that should read. There has to be a justifiable reliance by the parties, right, that were injured, and there has to be an injury. And these are different types. Okay, mail and wire fraud. I think you guys might have had a question about that in your assignment. And that's including now things like the internet, right? Be included in that, using interstate communications or whatever. Securities fraud, and that's kind of what we went back to when we saw Enron. If you go back and look at that, and we've seen decent amount of securities fraud, some insider trading and some different things like that have happened as well. Healthcare fraud, that people send. There's lots of other examples, I'm sure, of this, although I don't know a lot. But people sending untrue claims maybe in. And getting them paid either by the insurance company or Medicare or Medicaid, those types of things. Counterfeiting you don't see a lot of, which is kind of surprising. I would have thought with the advent of new color printers and those things, you'd see more people maybe trying that, but not as much. And bankruptcy fraud, yeah, we had a few cases that were close. I don't think we ever had a judge say, yeah, you've committed bankruptcy fraud, but we had some judges kind of, I think, look at some of the folks that had filed bankruptcy and said, you're verging on it, right? Oh gosh, it breaks all these down, but we had already kind of talked about that, right? Interstate communication, scheme to defraud, of course. Okay. Conspiracy, more than one person, right? So they're getting into it. I would guess the stuff that we're having happen out at Rocky Boy and the different parties, right? We got a conspiracy. We've had a conspiracy going on there, right? Each member, agent, partners, willful, willing, okay, those types of things. Commit overt act. Now, in some cases, and some of the parties might not have known all the details, and they wouldn't necessarily have, but they probably knew that they were involved in some shady stuff, right? Obstruction of justice, and that was the what's her name, Martha Stewart example that we gave, right? Act committed with intent to obstruct justice, so not providing stuff, right? Clean up files, maybe maybe you cleaned up or wiped files clean, like with a cloth or something. Oh, well, that would be Hillary, but that wouldn't be obstruction of justice, would it? Changing a record of phone conversations, shredding documents, that's the Enron joke thing that we had on there, right? And those things certainly have happened, right? It's probably getting more difficult with so much communication that's done, and there's certain requirements by ISPs or internet service providers and other providers to actually maintain the ability or some of those records, your phone calls, those things like that. So, depending on how you engage in conversations and whatnot and communications with other folks, it's getting easier sometimes to maintain those. So, to bank. False statements, and I had I had the FBI come in and investigate one of my customers one time because they had issued a false statement. That was kind of interesting. I don't think a ton became of it, other than I'm not sure that the guy didn't poop his pants when the FBI showed up at his doorstep and asked him some questions about it, right? And the reason it's a federal thing, and it's federal banks are federally protected, and so it becomes a federal crime. So to a federal agency, right? Willfully and knowingly relate to a material manner. I don't know what the exculpatory means, but trying to excuse oneself from responsibility. I don't know how that would relate to a federal agency. Maybe, I don't know. I'd have to look that one up myself. Larceny, unlawful taking of property. So you get all these, the robbery, burglary, etc., etc. Use of company property without permission. So if the company had a jet, and you were using that without permission, without paying it back, expense accounts, false buying time records, those types of things, along with the embezzlement that we've seen. We've had some cases. RICO, racketeer influenced corrupt organizations, something like that, right? What happens here is, this is kind of put in place back in the old mafia days, and what happened was you'd have the bosses, right? Well, the bosses got their money in rent. Okay, so they had people, underlings, that actually went out and enforced things and collected money and did all those nasty things that were certainly illegal, and then they paid rent to the boss or the don or whatever you wanted to call it, right? And the boss then was kind of out of the loop in terms of prosecution. And so they passed a RICO law, and they said, you know what, if you're using or investing income from prohibited activities, if you have any knowledge, then you can be found guilty, right, under this statute. Okay, acquire, maintain interest, same thing. So it kind of really broadened that, and it allowed folks to allowed prosecutors to go after, mafia dons and bosses and those types of things. There was a congressperson who was saying they wanted to use RICO to go after climate deniers. That's been in the paper a little bit. Kind of weird. It didn't get any place, and it won't, I'm sure. But a hacker or a cracker. I always thought cracker was a term for something else. What, I don't know. But right, people that get unlawful access, ID thefts becoming common, right? The whole Ashley Madison thing too, we saw all that, electronic theft, trade secrets, personnel records, customer lists. Yeah, you guys are probably more familiar. And then endangering workers, right? There can be assault, accidental things happen, right? We don't do the safety precautions, we take shortcuts, and those things can endanger workers. And just not requiring your workers maybe to follow those things can be maybe a company can be responsible for it. So I know the company, when they were building the brewery down there, I think a couple guys fell, and who knows if they didn't follow safety procedures or if the safety procedures weren't adequate, but the company ended up paying a pretty big fine. So aiding and abetting is a charge that says, if you've helped somebody in the commission of the crime, even if you didn't actually participate in the commission of the crime, you can be held accountable under aiding and abetting, right? Okay. State charge. In Montana, what I've seen is, I think, and it probably comes up on the next slide, but I think we call it accountability, right? You can be held accountable. And this is, the guy that drives the car after the bank heist, right? He was aiding and abetting, maybe. Well, and that he's probably participating in the commission of the crime, so that wouldn't be correct. But let's say the bank robber leaves and he's running down the street, and he gets a ride from somebody who knows that he just committed a crime. That would be more of an aiding and abetting type of a thing. Or somebody committed a crime and yet you shelter them in your home, right, and hide them from authorities. That would be aiding and abetting. Yeah, in the state of Montana, again, I think the accountability, they've got it italicized there, is the term that they used. And in here it says aid and abet somebody in the commission of a crime, etc., etc. So just know that, and I'm pretty sure that's on the test, that accountability is Montana's law. Bribery and kickbacks, public official, right, can be a federal charge. Those things happen, certainly. We've seen some of those here. Illegally, both domestically and internationally. So the Foreign Corrupt Practices Act. Walmart's been going through some, I don't know what you want to call it, but the criticism over what they've done in Mexico, right? Kind of interesting. Fixing a college or professional sporting event. Boy, go back to the old Black Sox, the 1918, or I forget what year it was, the Black Sox, when they threw the World Series. That's still known, right? Can you believe that it's such a big deal that the FBI has a sports bribery program? Wow. Wow, wow, wow. Right? Giving money back to someone who made a decision that benefited you or your company. So I think that's kind of what we've seen with what's been going on with Rocky Boy, right? There's a certain amount of that, right? So I'll choose you to be the contractor for this thing, and you give me back, 50 grand. Okay, that's what's been going on out there, and so we've kind of had firsthand knowledge of that. It's been in our paper, Lord knows, and the Tribune and radio, et cetera, et cetera. So. Some trends, Sarbanes-Oxley, that came about as a result of Enron. Actually, it should have been called the Enron Act, maybe. Those were the two Congress people. But Sarbanes-Oxley made some stronger. And we go over Sarbanes-Oxley when we talk about the SEC and stuff later. But it made it a little easier for the SEC to enforce some actions against companies and whatnot. Now we see prosecution for tax evasion. So maybe folks, you go back to the old who the heck was it? Dillinger? No. One of the old criminals, and they never could find him guilty of anything, but they were able to prosecute him for tax evasion. So we see this often, right? Plea bargained with mid-level employees in exchange for testimony. So we see folks that come clean, and they'll accept lesser sentences, etc. Yeah, that happens fairly often. The seizure of assets, and we had some cases where this has become really contentious, because we're seeing seizures of assets for companies, maybe only because they were suspected, because they made a cash deposit that was bigger than you'd expect or something, and they've had assets seized, sometimes for no reason, and it's affected business and personal lives and whatnot. And so this one's getting to be a little bit contentious, and it's going to be interesting to see how that shakes out over the next year or two through the courts and whatnot. So well, we got through that pretty reasonably, half an hour, so I'm going to call it good. And you guys have test 4 coming up this weekend, so good luck on that, and we'll talk to you next week.